Hi, and thank you for watching Missouri Viewpoints, the program dedicated to the civil and informed discussion of the political, social, and economic issues that affect us all. I'm Mike Ferguson, and as always, we're in the Hard Bean Cafe in downtown Grandview. Well, during this election year, we're hearing a lot about the executive and the legislative branches of government since candidates are running for all of those offices. We're also hearing a great deal about Missouri's third branch of government, the judiciary. Specifically, there's a lot of debate over how many of the judges are selected to be in this process. My guest this week is working to make some changes to that system. Bill Eckhardt spent his entire career in the legal field, spending over 30 years in the Army's JAG Corps, and is now a teaching professor at the University of Missouri, Kansas City's Law School. Professor Eckhardt, thank you for being here on the program today.
Mike, it's a pleasure to be with you.
Now, at issue specifically is the Missouri Plan, which governs the selection of judges for the state Supreme Court, for the Court of Appeals, and circuit criminal and probate courts in St. Louis City, St. Louis County, Kansas City now, Jackson County, Clay and Platte counties. Why should this system be changed, and why did you decide to get involved?
The Missouri Plan is some 67 years old, Mike, and it is in need of repair. When the Republicans in the 1940s countered the corruption in Pendergast era, Missouri crafted the Missouri Plan, and it was a jewel, and we should be proud of it. It's perhaps Missouri's gift to governance. Missouri Plan currently means selection by merit. And there's some 29 states that have the Missouri Plan. But they, contrary to Missouri, have modernized it. And we have not. They've made it more open. They've given the legislature, they've given the governor, they've given commissions more authority in this particular matter. We are the least representative, the most elitist of all, and we need reform.
We talk about what you say is the elitist nature. The way the system works, for those who aren't familiar, is a panel selects candidates.
We have a commission, Mike, and the Missouri Bar selects 3 attorneys. The Chief Justice sits as the 4th. The governor selects 3 citizens who serve for 6-year terms. That's the commission, and they meet and they present 3 nominees to the governor, who must select one or reject the panel, in which case the commission selects it.
Selects the judges and bypasses the governor in that situation. Now, one of the interesting angles of this whole debate as I was researching is the fact that both sides point to the fact that only 2 circuit judges, one in 1942 and one in 1992, have been voted out of office, and there's never been an appellate judge voted out of office under this plan. Supporters of the plan say that's proof that it works. People keep voting the judges in. Folks from, say, Better Courts for Missouri or other reform groups say that's proof that it doesn't work, that the people aren't in control of the process. Which is more accurate?
Mike, there are 2 parts to the problem. One is selection and one is retention. You're asking a question of retention. And the question is, what do we do when we have retention? I'm afraid of a shipwreck. The Chief Justice Wolf in 2007 in his State of Judiciary address basically admitted that the retention part is broken. Asked for more information, better distribution of information. But it frightens me. For whatever reason, 35% of all voters who go to the polls roll over and do not vote for judges. So that one can see that when judges are retained some 60%, that's not even a majority. Now, all it takes is one issue or one judge, and you have a real problem. And I think we owe our courts, and we just need a better system to do that. There's no information. And I'm afraid, in Kansas City, when we elected municipal judges some years ago, we went in, and I read vociferously. And I went in, and when I flipped the ballot and discovered I was voting on judges, I almost dropped my pencil. And I voted, but the problem was they had a very simple question on there, whether municipal court judges should be allowed to stay in office until their Social Security kicked in. And I thought that made ultimate sense. The citizens defeated it. And I think it's because they didn't like the court. That's the train wreck.
You said in a testimony that you gave to the Missouri General Laws Committee that, and I'm quoting, judges should not select judges, and you also said that the legislature should be more involved in selecting the nominees and selecting the judges. Why would this be a better system?
Currently, we have almost a private, semi-private organization selecting judges, and they are trial lawyers. The legislature's involved not at all. The governor, whoever he is, may only have one person on the entire commission, can't reject the panel, so that in effect we do not have a representative, accountable selection for judges. We think that the legislature, the commission needs to be bipartisan, and it needs to clearly be representative so we have appropriate checks and balances, and there are lots of ways to do that.
One of the criticisms that people who defend the plan as it is right now, a few weeks ago we had State Senator Jolie Justice on, who said specifically that making these kind of changes would inject partisan politics into what is a non-partisan court plan. How do you assess that statement, and how do you respond?
You'll never keep politics out of court selection. Thomas Jefferson, our founding fathers, the controversies. Nothing could be more political than the current system, where in the last years where they had some 5 or 6 candidates, there was only one Republican in the entire group. And if you look at not only was it political, it wasn't even on merit. When you have, there were 5 people selected, 3 of those went to the governor. You had people that were far more qualified who were in that 5 than went forward. It is political, and it is not meritorious. And our reform would make it less political and not more.
Let me kind of back up just a little bit, take a higher level view. Fortunately, I don't have any criminal problems. I don't find myself in court other than to deal with routine, matters, things like that. Why does this impact me? Why should I worry about this if I'm not somebody who has hardly any contact with the courts in the first place?
If you love your government and work to keep it working properly, the jewel in the crown is our judiciary. Always has been. It's been my privilege to serve my life as an officer of a court. And that is certainly true, and we ought to care, because they are a third branch, they are a co-equal branch, they're an incredibly important branch, and they absolutely need to be open and accountable. The reputation of our court, how it's held, the rule of law, all depend upon that.
You mentioned the accountability, and that's been another part of the debate. Some people have argued that judges should be elected just like everybody else, face re-election just like everybody else. How do you react to that claim, and should that be the case across the board? Should it not be the case at all? Should it be the case in different levels of the judiciary?
Those of us who started this reform are violently opposed to elections. What we need is quality control and political accountability. An election is extreme, and that should not be done. Now, in this state, circuit judges in most counties are elected, and they are elected because the people know them well. But there's a difference in a circuit judge that the community knows well, and courts of appeals judges and Supreme Court judges.
All right. Professor Eckhardt, thank you for coming on the program. I hope you'll come back as the issue takes more of the center stage in our news and in our governmental process. Thank you for watching Missouri Viewpoints. Be sure to come back next week when we'll have more interviews that affect you.